afternoon, everybody. Thank you for joining us again this month for another presentation of our first 30-minute series. This is where we take a topic that's typically of current interest or current events or something that we've seen just recently in the law and present to you and basically talk about it for the next 30 minutes, similar as if we were talking to one of our clients in the office, although I would, as a reminder, state that nothing that we are about to say should be construed as legal advice, and you should consult your own attorney or consult us if you would like to create an attorney-client relationship. With that, I'd like to say a special welcome to my colleague, Skip Sell. Hello, Skip.
Hello, Eric. It's great to be with you again.
All right, and I asked Skip to join because some of the issues that we're going to be talking about today, these are hot button topics that we are seeing in issues that are in lawsuits that are being filed both by criminal enforcement authorities and civilly. So up on the screen, you see our agenda. We'll just do a little bit of background on telehealth. We have a relatively new statute here in Florida that came about in 2019. We'll touch on some updates on payment and licensure in Florida, specifically in light of the recent coronavirus events and some of the changes that broaden the scope of telehealth services that could be provided and that would be reimbursed by federal payers and private payers. And then we're going to get into some of the new issues, and this is really, one area that we're going to talk about is anybody that's been watching the news would see that on September 30th, the Department of Justice announced in a long press conference, it's about 30 minutes long, a takedown of several fraudulent schemes defrauding healthcare funding around the country. And this was a multi-jurisdiction action. It covered maybe 14 states or so, several criminal defendants, and you hear frequently in that briefing and in the press releases that came out, telehealth and telemedicine being at the center of this. So where a few years ago everything was the opioid epidemic, now it's opioids and telehealth, and we're going to talk about those cases and maybe try and clarify some issues and dispel some myths. All right, so here's an issue that sounds easy on its face, but gets complicated once you start looking at some of the legal issues. What is telehealth? And you'll hear the terms, by the way, telehealth and telemedicine, and I have seen where this has been, where this discussion that these are distinct terms, where telemedicine refers to the actual practice of medicine through remote technologies, and telehealth is broader and encompasses remote monitoring and things even maybe as broad as personal digital health devices, things that you can get, apps that you can get on your phone, and maybe even dietary and fitness issues. But for our purposes today, I think the terms are pretty analogous. Skip, is that what you're seeing in the cases?
Yes, and Eric, before we even get into the definition of telehealth, I thought maybe it'd be a good idea to talk about how we got here, because I'm older than you are, but I was born in '57. In the decades right before then, house calls were common. That's how you did healthcare. Doctors came to your home. And there were some articles written about 3 years ago about how that was actually a less expensive way of doing it when you think about all the travel and the cost for having the doctor's office. Now we have the technology, right? And the technology is trying to
bring
deal
it
with
into your
still,
home.
It's bringing it home.
Interesting you say that. I put this little quote on the slide here that I had read from the CMS administrator, where Ms. Verma had referred to telehealth at one point as the modern day house call.
I think that's right. I think that's where it's going.
And it's interesting. There's the push-pull in policy and adoption and broadening the scope of telehealth seems to be this notion that if we allow broader scope of services, that costs could go up because of those services. But Skip and I were talking about this point yesterday, and Skip made a good point that perhaps insurance companies who profit from people being sick don't want healthcare to be as easily accessible. It's a pretty jaded view of insurance companies, and we're sorry if anybody out there hears that and might be offended. But it's just, we're just trying to think of the reasons why it may be adopted and expanded or may not. The one obvious reason against is the potential for fraud, i.e. the huge legal announcement that just came out of DOJ. And there's been a couple other really, really big cases, multi-billion-dollar cases where people are using telehealth, the fact that folks are remote to pull off scams, and they do that with computers and everything else.
Well, and just before we go back into the definitions, to your point, Eric, when the DOJ made that announcement, they were talking about more than 300 defendants being charged, 100 licensed medical professionals being charged, $6 billion of alleged losses, and 30 million prescribed opioid drugs. So from that perspective, big problem.
Almost out of control. Huge expense for federal government, huge expense for the taxpayers, for the private payers, and it creates a potential drain on the system. But what we're going to see here is, I think, some of the some obvious bad players out there. Quid pro quo, writing prescriptions for kickback payments. But probably a lot of innocent folks who are getting caught in the dragnet as well.
And that's the backdrop to the Florida legislature trying to deal with these definitions of what is telemedicine.
So, when we look at this, and some of the information, we're going to provide you stuff from the statute. The relevant statute is 456.47. It's the Florida Telehealth Law. The statutory site is there on the slide. And there's some terms that they come up over and over when we're talking about telehealth. And this is useful to know if you are in a position of advising somebody, if you're a lawyer or an advisor, advising somebody that's considering adopting a telehealth practice or getting involved in telehealth. We have some physician clients who have been engaged in providing telehealth services. You want to know specifically what is the expectations are in providing a service, and understand that in the context of these definitions. So this is important stuff, even though it's a little dry. The first here is the Florida statute, which, by the way, the background materials, if you read the House analysis report and a report from the telehealth, what was the Telehealth Advisory Council before the law came about back in 2017, seem to acknowledge that there's no universally uniform definition among states or government bodies of telehealth. Everybody has an idea of what it is, but nothing direct. And one of the big issues is synchronous and or asynchronous communication. Here in Florida, we've specifically defined it as synchronous or asynchronous communication where healthcare providers can provide service to patients.
Eric, I get that it's not uniform on a statewide basis for the definition of those terms. Is there guidance that is national for those terms?
Folks look to CMS typically.
What's CMS?
For Centers for Medicaid and Medicare Services, for what CMS will pay for, because they're typically leading the way. But even nationally, no. And we've spoken, actually, Skip and I were on a call with a very prominent telehealth attorney up in Washington, D.C. area just earlier this week. And I believe he even said during the call that he's not aware of any universal definition at national or state level for telehealth. But some things that are generally accepted is that you have synchronous communication or asynchronous communication. And that's communication in both of those forms. It's going to be communication that's not live with the patient. You're not sitting in the same room with the patient. Synchronous communication generally refers to real-time communication, where asynchronous communication, one description of that is the relay of information with lag time. You provide, maybe a patient provides information now, and a provider reviews that information at a different time and perhaps makes recommendations or some type of analysis at a different time. A common example that we see all the time, frankly, is with X-ray or MRI analysis. You have photos done, and there might be a physician, a specialist who looks at those photos and provides some type of analysis to your primary care physician or whoever sent you in for those photos, but you may not ever meet with that person. They're still providing care, but that's a common example in everyday practice of an asynchronous type communication. When we're talking about telehealth, again, no universal definition. Some states don't provide for asynchronous communication included in their telehealth definition, but Florida, after careful analysis, in my view, specifically made a point of adopting asynchronous communication as part of the telehealth statute. And to that point, I'll also note that this is the bill analysis that was done in the Florida House before the House bill, I think it was House Bill 23, became the statute. In that analysis was written that telehealth generally consists of a synchronous or asynchronous transmittal of information, synchronous referring to live transmission, and asynchronous telehealth is the transfer of data over a period of time and typically separate time frames, commonly known also as store and forward. Right. So this becomes a question because some people have the belief that the care has to be provided in a video conference call. That's not really the case. I mean, a video conference is one modality.
So I've heard some other terms used, and where do those terms fall in for synchronous and asynchronous, like person to person?
Person to person, well, it gets a little bit gray because you can be face to face in a video call. Is that face to face? That's a synchronous communication, but it's not live if the person's not sitting in your room. Person to person to me is not specific enough to say whether you're in the same room with that person, on a video call with that person. Yesterday was my father's birthday. I got to speak with him and say happy birthday, even though I don't get to see him very much. Were we talking person to person? In a sense, we were, but we were on a phone call.
So if you use that example and it's recorded and then it's forwarded to a sibling, would that be store and forward?
Store and forward might be a voice message.
Could it be a video?
It could be a video. We actually filmed a video of the kids last night singing happy birthday to my father and sent him the video. Store and forward, asynchronous communication, but most certainly a communication. Most certainly the message was there and hopefully received as it was intended. So in the healthcare context, can a video recording that's not done in real time constitute treatment of a patient? And that's really an open question. And folks, the reason we're talking about this is because this seems to be one of the hot button issues that we're going to see in the courts. Florida has specified what is not sufficient for communication, and that's in the statute. The treatment can't be based on simply a phone call, a fax, or an email. So it has to be something beyond that. But the gathering of information and then the forwarding of that information, in some form other than just a fax or an email.
That's why that's so great to me, Eric, because what does that mean? It can't be by phone. For example, if a patient calls the doctor, is that not allowed?
Is that considered treatment by telehealth under the Florida statute? No, but in light of COVID, as we're going to see, there's been some relaxing of some of the standards and rules, and CMS will pay, and a lot of private insurers, I believe now, will pay for check-in phone calls and treatment by phone because we've ordered everybody to stay home for COVID.
Sure.
And in addition to that, CMS revised some of the rules I believe it was last year, to allow in certain circumstances for check-in phone calls. So where Florida has said not by phone in 2019, I think it was 2019 when CMS came out and said, well, there's certain circumstances where, a follow-up phone call, we're going to pay for that because the physician has to get on the phone, maybe. And now the initial treatment can't probably be by phone in that circumstance. But under COVID, we've seen a lot of communication done by phone, relaxed standards with respect to the security of the mechanism used for the communication, video calls, and so forth, where we were worried before about those communication devices being more secure. Mm-hmm. And now we're allowing things like FaceTime, yes, to comply with HIPAA requirements.
What about this situation? You have a real-time communication with a patient, and it's videoed. and the patient goes through their entire history. Well, let's say even the patient is physically examined, and then that video is transmitted by email. Is that okay in Florida?
Transmitted by, so one person does the examination and another, and the video is taken of the examination and it's forwarded to another person. If the person doing the examination initially is a healthcare provider, I think generally yes. If not a healthcare provider, but based on the facts that you provide, I think we're going to see that be sorted out in courts, whether that's sufficient. Just the recording is done of an examination by not a qualified healthcare provider, but someone else, maybe a nursing assistant or something that doesn't fall into the definition of a healthcare provider. And I think we're going to see that now. Somebody just, can I have somebody just videotape me and describe something and send it to a physician for treatment? Maybe that's not enough, but if that's coupled with an extensive questionnaire and review of my background and history, perhaps it is. So as you can see, folks, again, gray area there. If you have questions, fire them out to us. We've got this for a half hour, but these are great questions because these are the things that we're seeing in the courts right now. So here, this is a question. I took this right off of the Florida Department of Health Q&A. Can patient evaluations be conducted by telehealth providers via telehealth? And the response was essentially yes. If a telehealth provider conducts a patient evaluation sufficient to diagnose and treat the patient, the telehealth provider is not required to research the patient's medical history or conduct a physical exam before using telehealth to provide healthcare services. Now, this question, sufficient to diagnose and treat the patient, that's going to be, again, an area that's gray. And one of the goals in passing this law, and what is often a goal in passing a statute or legal authority, is to provide folks with a solid definition of what's allowed and what's not allowed. I think the statute does that, but the statute also raises some additional questions. And that's, what is this level that's required to conduct a patient evaluation? And I think at some point you just have to rely on the professionals. Same thing for lawyers, for physicians, for other trained professionals. You need to understand when your patient, doctor-patient relationship starts. And same as a lawyer has to understand that even if a client comes in and talks to you and doesn't hire you and leaves, that you may still have a duty of confidentiality, most certainly, and you have to be careful of whether or not you have formed an attorney-client relationship with that person, even if they didn't actually hire you for the task. And lawyers, a lot of lawyers, and folks, maybe if they're on, will know this. As lawyers, we typically, if we decline representation, we'll put something in writing and let people know that we've declined the representation, so it's clear. In this context with telehealth, I think it's, if a physician is reviewing patient information and feels confident in reviewing that information, that they can make some type of treatment diagnosis and it's not prohibited by a statute or rule, probably okay.
What's interesting about the answer to that question, what you just said, even after a doctor creates the patient-physician relationship, there's a standard of care issue. This says a patient evaluation sufficient to diagnose and treat the patient.
Absolutely.
That's a standard of care.
That's right. Standard of care issue. And so that's going to be a question that we'll see. I'm waiting for the malpractice claim to be filed based on the accusation that you made a recommendation and didn't sufficiently examine me because you used some telehealth modality. I haven't seen that yet, but what we're seeing is federal government crackdown, because they're saying that telehealth prescriptions are written fraudulently in a quid pro quo arrangement. And then we're also seeing private insurance companies object to payment potentially based on improper telehealth services, overuse, or making prescriptions for things that are not medically necessary.
In that second example that you're given, they are trying to say that in part there was no physician-patient relationship established, so any prescriptions written in those civil proceedings by the private insurance companies are flawed and were medically unnecessary. And that's what's so interesting to me about that is they're saying that services were rendered without a patient relationship. But if it was turned around on a standard of care issue, and this patient sued those same doctors for having prescribed that medicine, I wonder how successful the doctors would be able to turn around and say, oh, they weren't our patient.
Not at all. No, the doctors are going to be responsible because they're the professional. And but you make a good point. You know, the doctors will be responsible for the patient-client relationship, but you have the folks, you know, the companies who may not want to pay for that consultation or that engagement, saying that it wasn't sufficient to form the relationship, which seems like an oddly circular argument. So who can provide services? We have a list here. I'm not going to read through all of these, but you have these slides, so you can keep these for yourself. I do want to hit on these times go so fast. We could probably talk about this easily for an hour. But continuing with the statute, in state you have 456.47 is the Florida statute for telehealth. There's for nurses, there's a multi-state compact that can be joined, but that's not available for physicians at this time. There is also registration of out-of-state providers available under the telehealth statute. The registration process is fairly straightforward. There's several registrants right now. It's not it's a no-fee application. You basically just have to have a valid unencumbered license somewhere else, show financial responsibility through a letter of credit or insurance, and have a registered agent so you can accept service in Florida. And if you're going to register as an out-of-state provider, you can't have an office in Florida. Again, similar, there's an analogy there to appearing pro hoc vici if you're an attorney in a case in a different state or jurisdiction, except for those instances, it's a one-shot deal. Here, you can provide telehealth on a regular basis as long as you're registered.
Can I ask you, if you were comparing this as an easy or a stringent standard in order to provide service, which would it be?
I think this is pretty easy. This is pretty straightforward. You meet the minimum requirements. It's not a selection process. There's no testing process. It's not like
there's no
like
vetting.
A license. There's no vetting, right? It's not like you have to pass an exam and meet certain educational requirements in order to become registered. It's really just an administrative registration process.
No excuse not to.
No excuse not to, and I don't know what happens if obviously people should be registered. Anybody who has any questions about that is welcome to contact us. Again, it's a pretty straightforward process, but we have seen some folks apparently don't realize. And the other thing is, by the way, if you're a physician or another provider providing telehealth services through a company, you better darn well make sure that company is only providing you with access to patients where you are licensed or registered properly to practice. So if you're providing services in Florida as an out-of-state provider, you're a guy in New York and you sign up with a telehealth company and then you get these patients sent to you, you may not think to look and see where these patients are from. You just assume, okay, I'm licensed in Florida, they want me to see patients. What if it's a company that either isn't well managed or the company's just downright crooked and they have you now seeing patients in other jurisdictions and you're unaware of it?
That's a great point.
So if you're going to, and where want to go with that is if you're going to sign up with one of these providers, there's huge ones like Teladoc, there's a bunch of telehealth providers out there, make sure you know who you're signing up with and do your due diligence so you would know exactly what the modality is for providing the services, how you're going to do it. And it's kind of on our last slide I was going to hit on, but really understand who you're going to provide services with. We've got, this went so fast. I skipped to jump in because, again, we've been seeing these issues a lot. I do want to hit on the most recent events. So I'll hit there on the next slide. Please feel free to go through this yourself. There's a couple of statutes that are under limitation for providing prescriptions of controlled substances. That's not every prescription. It's just controlled substances that are outlined in the statute. And so understand that there are restrictions there when you're doing prescribing. Otherwise, prescriptions can be made by telehealth. And I think we've been touching on some of these open issues as we've been going through the statute itself. What's the proper mode of communication? Location, if the patient's going to be remote and if the physician is out of state, then that physician wants to make sure they're properly registered or licensed in Florida to provide the services. And another issue with location is if a lawsuit does arise, the proper venue and jurisdiction is going to be in the location where the patient is located. And that's pretty universal in statutes I've seen elsewhere. Payment, we do not have a payment parity statute in Florida. I think about 10 states do. That basically the payment parity is that services provided by telehealth are paid the same as if they were provided in person. Florida does not yet have one. It was the Board of Medicine did send a letter to the governor back in March asking for expedited passing of a statute or law on payment parity, but that hasn't gone anywhere. There was a proposed law last year that didn't go anywhere, and I think there's strong opposition from the insurance lobby, and there's some reasonable arguments on both sides of against payment parity. You don't have the same overhead; it's easier to provide the services. And then federal action, as I mentioned earlier, CMS, their rules typically lead the way on telehealth. I'm going to skip this just so we have a couple minutes to talk about the most recent events. I do have some updates in the slides here. Again, the emergency order that expanded services that could be provided by telehealth and relaxed some of the standards. That was we had a Florida emergency order that trailed the governor's executive order. That order is still in effect. And then we also had CMS with Medicare substantially broadening the scope of services that could be provided and paid, and relaxing standards for HIPAA and the pre-existing relationship requirements that were in HHS guidelines. Also relaxed standards for cost sharing. So during COVID, understanding that a lot of the economy, folks in the economy are suffering, standards for waiving co-pays, for instance, and co-insurance were relaxed. But if you're working for a company that routinely does not charge for telehealth services to the patient, or if they're waiving co-payment fees or other fees, again, as a provider, that should be a huge red flag. If you know that fees are being consistently waived. In Florida, we actually have a statute in the insurance section that essentially says that waiving co-pays as a routine business practice can be considered a violation of law. And then Florida followed with Medicaid, again expanding services that could be paid and relaxing some of the standards. And then the Florida Medicaid did provide for some degree of payment parity. So private payers, no, but Florida Medicaid, yes. Private payers, again, case by case here, no payment parity, but that can be negotiated on a case by case basis with each insurer. And we've got about 2 minutes. I just want to point out that there's been a couple law enforcement actions. Gosh, Skip, I wish we had another half hour to talk about these.
Can we go over a couple minutes?
Sure, we can go. Maybe if folks stick with us, we're going to record this. And if you'd like to stick with us here for a few minutes, we have some folks on. We're happy to field any questions separately. If you'd like a copy of the recording when it's done, we're happy to provide you with a copy of the recording. Let's stay on for about 5 more minutes. And again, and if you are looking for credit for this, there's I believe we have eligibility for 1/2 CLE or continuing ed credit for certain folks. So contact us on that. We can show you how to get that credit. But I'm looking out here to see if we have any questions, and I don't. I see several folks on, but let's talk about. We had a case in 2019. Some recurring issues that we're seeing with law enforcement. These are, again, this is criminal actions, but 2019 the DOJ cracked down on what they called a scheme that targeted elderly patients where cancer and genetic tests were being ordered through telehealth. And what happens in that scenario is the testing company is paying the prescriber for prescribing those, for ordering those tests. So again, you can't get paid by the pharmacy. You can't get paid by the testing company. If you're the physician, they can't be the one paying you to write the test for somebody. That's a straight up kickback and obviously illegal. April 2020, a telemedicine owner was charged with a $60 million fraud scheme for illegal kickbacks that were being paid to medical providers for ordering durable medical equipment. And in May 2020, we see another scheme where kickbacks were being paid to the companies and for marketers for ordering bundled respiratory and COVID tests. And that leads us into the September law enforcement action that was just announced, where several defendants were arrested or charged with crimes involving wrongful prescription of opioids. And essentially what they were doing is trading prescriptions for, it was a pure quid pro quo. The physician, at least as described, it was, of course, it's early in the action, everybody's presumed innocent, but the way that was described was the physicians providing prescriptions almost directly to pharmacies. And then some of these were compound products that the pharmacies made up, and they used expensive ingredients, and they paid the physicians to write these prescriptions, and then the pharmacies turn around and bill the insurance or bill Medicare, Medicaid, and were obviously billing them pretty extensively. Over 250 individuals lost their Medicaid privileges, or Medicare privileges, pardon me, from CMS, got put on a revoked list. Go ahead, Skip.
Well, yeah. Well, I want to thank you for including me in this. Also thank the people who stuck with us, because I think it's important to hear this final message that we want to give, which is it's really important to be careful right now when you're out there. Because we were just talking about CMS and broadening definitions and broadening payments, and at the same time they're going ahead and revoking, what was it, 265?
200. They added 260 some odd names to the ineligible
debarment list.
Right. The debarment list, so they could not charge. And once that happens, you basically, if you lose your ability to bill to Medicare, that's almost a death knell for practice, because no group is going to hire you if you can't, if you're on that list. They're prohibited from billing Medicare, from hiring anybody that's on that list. And from a private, that's the number one payer in healthcare, it's federal government.
And we know that if you're accused of any type of healthcare fraud, it can result, just the accusation can result in loss of job, loss of income ability. If you're debarred, that certainly would result in that too. So the message is to be very careful, because we're in a state of flux. Now, if you go and you look at the actual allegations in these criminal and civil complaints, Eric, you can see that the other words you use are really important. Quid pro quo. I mean, there are bad things going on. There's kickbacks, there's illegal payments. Those are kind of the easy black and white cases, but because of the lack of definitions in the statutes here and around the country, there's gray areas that we talked about before. So that takes me to the other word of caution. If you're a provider getting into it, you got to know who you're getting into bed with.
Yes, that's it. You really need to. I've looked at several telehealth contracts, and in full disclosure, Skip and I are both involved in some telehealth litigation. We haven't talked about that litigation, and we won't, as long as that's ongoing. But we represent some folks involved in litigation now. But in reviewing these contracts, you really need to know, what services are to be provided, who's paying for the services, how are the patients coming to you, where are the patients from? The big question, the question I ask all the time when I'm trying to figure something out, is how does everybody benefit? How does everybody make money? If you're signing a contract, how is everybody else making money? If somebody's just sending you patients and you're providing the service, is that company, are they providing it for Disney and Lockheed Martin, and they're providing private services? Are they working for an insurance company? Who's paying? Is insurance involved? It'd be good to know that. Do you have to be credentialed with any particular insurance companies? And are there federal payers? When you get into federal payers, you get into potential criminal issues.
And these contracts, for the ones that I've seen, you're making representations and warranties as the provider that you're in compliance with all the rules, regulations, state and federal law. As a provider, you need to know what that state and federal law is, and it's in flux and it's changing. So be in contact with folks that can help you along that process to make sure you're doing it the correct way. And the other thing is, it's kind of like our parents said, if it's too good to be true, it probably is.
Yes.
If you're being asked to provide services where it just seems like it's just too good of a deal, that's a big red flag. Listen to your gut.
Thanks, and have a great and safe rest of your day. Bye-bye.